let me just dive in. In 2005, while serving as the senior Democrat on the House Intelligence Committee, one might call that an oxymoron, House Intelligence, I spoke at Georgetown Law School, where decades before I had been an adjunct professor, by the way, on the topic of intelligence gathering in the fog of law. Apologies to General Clausewitz and his famous term fog of war, but the association was deliberate. In that lecture, I decried the inability of Congress and the executive branch to debate fully and explain to the American people, both of those things, debate fully and explain a post-9/11 legal framework to address many of the same issues that I intend to raise again today. Issues like cybersecurity, foreign versus domestic intelligence gathering, targeted killing, and preventive detention. 7 years ago, I said, we live in an era of terrorism. Our laws were created for a different era, when the enemies of the United States wore uniforms, the battlefields were clearly defined, and wars ended with the surrender of one nation to another. In this era, the enemy doesn't wear uniforms. The battlefield is the entire globe, and the war is potentially never ending. Our legal system has not yet adapted to this new era. The enemy is digital, but our legal system is analog. I could have said the same words 7 minutes ago. Although we have reorganized our intelligence structure, an effort in which I played a major role, and a hallmark of President Obama's first term has been his aggressive approach to fighting terrorism, we still have never had a real debate in Congress or in the public square about the intersection of our values and our requirements for gathering intelligence. The result is a hodgepodge of internally inconsistent policies, an outsized role for the courts in interpreting and, in some cases, striking down those policies, and huge gaps in what the public knows and has been told. Recent questions raised about the nature of the NYPD's surveillance of mosques are just but one example. This afternoon, let me highlight policies and discuss some of the tough issues that, more than a decade after 9/11, Washington still hasn't solved and perhaps can't solve. I'll also try to define a way forward. I suggested back in 2005 that the threats of the 21st century required Congress to create a new legislative and oversight framework because, without such guidelines, the actions of our government were gradually being pulled off their constitutional moorings. Previously solid lines, like no torture, no detention without a legal status, no warrantless surveillance of U.S. persons, had become dotted lines. I called for the country's best legal minds to come together, perhaps in the form of a national commission, to help Congress and the administration create, and the American people to understand, a new legal framework for confronting 21st century threats. This lack of legal clarity breeds other problems. When we fail to enumerate clear policies, those expected to implement them either become risk-averse or feel enabled to commit abuses. Think Abu Ghraib, or the more recent example of Quran burnings in Kabul. Granted, that second latest awful episode had more to do with cultural insensitivity than intelligence gathering, but have we learned nothing in the 10 years since we went into Afghanistan? As former CIA Director Mike Hayden put it, think of clear rules and policies like the lines on a football field. Intelligence officers need to be able to, or must, not just need to be able to, must get chalk on their cleats. But in order for that to happen, those chalk lines need to be bright and well-defined. Sadly, all these years later, and with often unanticipated political upheaval accelerating around the world as the backdrop, these matters are still far from resolution, and we have mostly only ourselves to blame. One of the biggest reasons we've made scant progress is Congress's ongoing and exquisite dysfunctionality. As you heard from Phil, I served in the House for 9 terms, And I've seen up close and personally how the toxic paradigm of finger-pointing instead of bipartisan problem-solving has created almost total legislative gridlock. What passes for serious debate occurs within a tiny bandwidth, leaving little chance to raise the tough issues, let alone to resolve them. The destructive partisanship is palpable and pervasive. It is a major reason I decided to leave Congress last year to become Director, President, and CEO of the Wilson Center, a safe, nonpartisan space where members of the House and Senate can do deep dives on issues and talk about them in a way that's hardly possible anymore on Capitol Hill. And that's why lots of members of Congress currently serving come on down to the Wilson Center and join our panels. Here's a humorous aside, but one that's a good illustration of how inconvenient the last president, I'm segueing now to the executive branch, which plays a role in the dysfunction too, how inconvenient the last president considered legislative branch attempts at oversight. I happened to find myself in the White House hallway some years back in the Bush 43, I think, first term, face to face with then Chief of Staff to Vice President Cheney, David Addington. One makes the most of such moments, and I told him I believed that Article 1, Section 8 of the Constitution, the so-called capture clause, which states that Congress shall have the power to make rules concerning captures on land and on water, gave Congress authority to do what I was hoping we would do, which is provide new rules for detentions and interrogations of detainees and enemy combatants. The always gracious Addington simply smiled and said that such authority did not cover what I was talking about. He said the capture clause applies only to piracy. Now, I would hope it would apply to piracy, but excuse me, I do think that the Constitution not only covers but compels Congress. Article 1 applies to the legislative branch to act on such matters. So now we're deep into the 2012 election cycle, and that makes action on such topics by the President or Congress highly unlikely. Discussion of these issues must be high on the agenda, I think, for the next president, no matter who he, gender seems the only given at this point, may be. America's leaders have an obligation, indeed a very heavy burden, to tackle them. I'm going to list and discuss briefly my top four. 1, Guantanamo Bay Prison. The entire notion of Gitmo was cynical from the outset. The Bush Justice Department believed that habeas corpus, the fundamental right to ask a judge for release from unjust imprisonment, did not apply to a location not considered U.S. soil. In case you missed it, we rent Guantanamo, which is a piece of the island of Cuba, from the Cubans, and we have done so since the early 1900s. Hundreds of detainees and enemy combatants were flown to Gitmo, especially during the early days of the Afghan war, before a prison was even constructed. I saw the first, I didn't see them arrive, but I saw where the first group of prisoners, which was most of them actually, were placed. In case you missed it, they were in wire cages resembling large chicken coops. I've been to Gitmo 3 more times, and I have seen it evolve into a state-of-the-art prison facility at a cost of almost $600 million since January 2002. But isn't it ironic that much of the inmate hierarchy and command structure developed when barbed wire cages permitted free communication among the prisoners, and none of the subsequent improvements has been able to disrupt that? On his second full day in office, President Obama issued Executive Order 13492 to close Gitmo within a year. He was committed, in his words, to fixing the mess at Guantanamo. I applauded his effort and still argue and still believe that Gitmo should be closed, but the issue proved to be much tougher than he and his team anticipated. Files on individual inmates were incomplete, and in many cases, the so-called evidence tree could not be rebuilt and was therefore inadmissible in federal court. In March 2011, President Obama essentially abandoned this pledge to close Gitmo, issuing another executive order which codified the system of charge-free indefinite detention, and also the system of military commissions, all but cementing the prison camp's continuing role in U.S. counterterrorism policy. Congress, too, stymied the president's original intent by blocking the transfer of any of the 171 remaining prisoners to the U.S. for civilian trials. Congress first spooked itself and then launched a politically expedient campaign to spook the American people by invoking visions of grisly terrorist killers wandering around American neighborhoods. The notorious Willie Horton ad comes to mind for some of the older folks in the audience. Congress's ironically bipartisan misbehavior leaves military justice as the only way to clear the backlog of prisoners. And yet many of you are probably aware that military courts or military commissions have secured only a handful of convictions since 9/11. In contrast, more than 400 people, both U.S. and foreign nationals, have been convicted of terrorism-related crimes in Article III federal courts and are now serving long sentences in federal supermax prisons. And so far as I know, none of them has escaped to walk around in some grisly profile in any nearby neighborhood. Some of those behind bars for life include Omar Farouk Abdulmuttalib, who was the Nigerian Christmas Day bomber, Faisal Shahzad, the Times Square car bomber, and Ahmed Gilani, a conspirator in the 1998 U.S. Embassy bombings of Kenya and Tanzania, and 3 individuals who plotted an attack against JFK Airport in 2007. We've had similar success trying and convicting homegrown terrorists in Article III courts. North Carolina's Daniel Boyd pleaded guilty to conspiracy and to provide material support to terrorists, among other offenses. Illinois' Michael Finton pleaded guilty to attempted use of a weapon of mass destruction in connection with detonating a truck bomb outside of a federal courthouse. And as I mentioned, none of these people has ever escaped custody. The administration estimates that it costs taxpayers $800,000 per year to keep each detainee at Guantanamo. That's more than 30 times what it costs to keep an inmate at a civilian prison on U.S. soil. President Obama issued waivers last month that would exempt broad categories of future prisoners from the requirement that foreigners suspected of being al-Qaeda operatives be held in military custody rather than proceed through the civilian criminal justice system. Without these waivers, law enforcement argued it wouldn't be able to persuade suspects to cooperate. That same month, Majid Khan, the very first high-value Gitmo detainee, reached a plea deal with prosecutors to serve no more than 25 years on war crimes charges if he testified against other terrorism suspects. Perhaps we can expect similar successes, and turning a captive like Khan is a success going forward. But to conclude this subject, the tough questions remain on hold. For Gitmo's so-called final 15, the worst of the worst detainees, where we have inadequate evidence to charge and try them, but are also persuaded they are too dangerous to be released, even to other countries willing to accept them, is the answer to let them go free? And if not, does preventive detention, a policy that President Obama has begun to articulate, square with our Constitution and our values? That's a debate we haven't had. Should the Geneva Conventions, which specify procedures for capture and imprisonment of enemy combatants, be reviewed and updated? Another conversation we haven't had. Second subject, the blurred line between domestic and foreign intelligence. Among the intelligence failures on 9/11 was an internal FBI policy that prohibited the mixing of intelligence with criminal information. Sadly, that policy prevented parts of the FBI from talking to each other, which could have revealed the identity and location of 2 of the prospective hijackers who were living in San Diego with an FBI informant. Just wrap your head around that one. After 9/11, the law enforcement community, from state and local police to federal agencies and even a few private security contractors, understandably sought to expand their capabilities to thwart terror attacks. A few police departments in this country began to operate far outside traditional jurisdictional borders, even sending officers to the Middle East. And some, like the NYPD and the LAPD, were also criticized for targeting ethnic communities, and not just because of alleged racial profiling. Police departments deployed undercover officers into minority neighborhoods as part of a clumsily created and named human mapping program. Informants even monitored sermons at mosques. And now, as I mentioned earlier, NYPD Police Commissioner Ray Kelly argues that his program, which has been heavily criticized, is misunderstood. He might be right. But again, people really don't understand his program. Second concern is the rapidly growing use by domestic law enforcement, including a few federal agencies such as U.S. Customs and Border Protection, of drone flights over the United States. Currently, such flights are infrequent, and authorities claim it's easy to keep tabs on their activities. For years, they argue, unarmed drones have flown legally over the U.S. for a variety of reasons, including disaster protection and management, border security, and during large public gatherings like the Super Bowl and the World Series. However, as a recovering politician, there's no 12-step program for this, by the way, who served on all the major security committees in Congress, I understand, and I'm sure some of you do too, exactly what drones can do and what they will be able to do in the future. Law enforcement agencies tell you they're just like helicopters, but Grandma here disputes that. They have a long dwell time. Unlike loud helicopters, they hover silently. And in fact, earlier this week, an article in Politico described drones as small as hummingbirds, literally containing imaging technology that can shoot video through the window pane and thermal equipment that can see through walls. Doesn't sound like a helicopter to me. And oh yes, what about the constitutional requirement of an individualized warrant to spy on a U.S. person? Nonetheless, the FAA, the Federal Aviation Administration, is issuing hundreds of, quote, certificates to police, government agencies, research institutions, and even private citizens to allow them to fly drones, small drones of various kinds over the U.S. The FAA Reauthorization Act, which President Obama signed in February, orders the agency to develop regulations for the testing and licensing of commercial drones by 2015. Contrast this. In 2009, I was able to cut off congressional funding for the deceptively named, or I thought so, National Applications Office, the NAO, which was a Homeland Security Department program. The NAO was created by the prior administration to permit military satellites to operate over the U.S. for law enforcement purposes. Congress rightly brought the NAO to a screeching halt, because if you think that drones are effective information gatherers, you can imagine what a billion-dollar satellite can do. Don't get me wrong, state and local police, our cops on the beat, are more likely to identify and disrupt the next terror plot than is a bureaucrat in Washington. And there have been many, many successes. But we need a conversation around the use of new technology which can very effectively collect information on us individually, including things we're doing inside our homes where we have an expectation of privacy, and we haven't had that conversation. Here's a related conversation that we hope to have, but which, as I will explain, blew up. Few would disagree that we should understand better the tipping point between the use of constitutionally protected language and radical views and the individual decision to commit a violent act. Having radical views is protected by our First Amendment. Committing violent acts is not. And so the issue comes, when and how should one intervene if an individual is on this path from the possession of radical views to the personal decision to engage in in violent behavior. Congress, or at least I, wanted to understand how this works, and I authored something called the Violent Radicalization and Homegrown Terrorism Prevention Act. Bruce may remember this little war. The act passed the House of Representatives twice by over 400 votes. That's a huge bipartisan majority, since the House only has 435 people in it. The bill was deliberately narrow in scope and would have done nothing more than create a nonpartisan commission to study the issue and then report to Congress. The commission wasn't going to do anything other than help us with psychologists and anthropologists and others who could predict human behavior, help us understand what that line is between radical views and violent behavior. But after it passed the House twice and was sent to the Senate, certain privacy and civil liberties groups, many of whom had been in the room as we drafted the bill, attacked it and attacked those who voted for it, arguing that it was a slippery slope, and their actions blew up the bill before it ever was considered in the Senate. And so the legislative branch proceeds without any tools. There is a little light peeking through the fog. President Obama has finally actually named people to the Privacy and Civil Liberties Oversight Board, which was established by the Intelligence Reform Law of 2004. The board advises the president and other senior executive branch officials about the privacy and civil liberties implications of counterterrorism laws, regulations, and policies on the front end, so that we try to make privacy and security reinforcing values, which I would argue they are. See, we're either going to get more of both or less of both, and this way could guarantee that we will get more of both. At any rate, the board has been essentially dormant since the legislation was passed, and now we have a chance of really standing it up, and I consider that to be good news. Third issue, cybersecurity. Several high-profile events over the past few years, from the infiltration of the Pentagon's $300 billion Joint Strike Fighter program, the Stuxnet worm that cut through Iran's industrial control system, and even the computer-generated assaults that preceded Russia's 2008 hostilities with Georgia, the country of Georgia, highlight the complex threat of cyber attacks on governments. And the recent hacking of companies like Google and Western energy firms reveals how easy it is to cripple the private sector as well. That's why we need to get representatives from the private sector and government in the same room to talk about protective measures. Clearly, the role of the private sector in our nation's cybersecurity is huge, and I believe government can learn a lot from the private sector in this and other matters. But current U.S. policy relies on the voluntary participation of private industry, which, of course, is loath to allow a public airing of some of its most proprietary activities. Without a clear framework for public and private cyber partnerships and information sharing, corporations will continue to make decisions based more upon their individual self-interest instead of the national interest. We must hammer out a way to balance the cybersecurity interests of corporations with the need to protect America's infrastructure. Wide gaps in U.S. cybersecurity policy make it hard for the public to understand what we're doing about this issue and how we're going to keep them safe, to keep the internet, the electrical grid, and the aircraft control network fully functioning, for example. The National Security Agency proposes monitoring private computer networks in real time to prevent cyber attacks, but because people mistrust, or many people in the private sector and the population mistrust NSA, the White House and the Justice Department have so far rebuffed these efforts, and again we fail to have the necessary conversation. Like so many other issues, cybersecurity has become far too politicized. As a result, we lack clear guidelines about how much authority the government has in the event of a cyber crisis. Outside groups have alarmed people with the idea of an internet kill switch, which would allow the president to shut down the entire internet in extreme circumstances. Kill switch hype has curtailed much needed debate about other key aspects of cybersecurity. And I find it quite ironic that one of the bills introduced in Congress, of course, Congress is having a fight about which legislative package is better, and it's not clear to me that anything will pass. But one of them, at least in initial form, said in its absolute first clause, there shall be no internet kill switch, reflecting the fact that that conversation had to be stopped in order for anybody to read another line in the bill. Fourth and final topic, targeted killings of Americans. Targeted killing is one of the toughest unresolved issues. While the law remains unsettlingly unclear on a number of national security matters, I do applaud Attorney General Eric Holder, who I think last week gave a major speech lifting some of the fog over this particular matter. He was at Northwestern when he delivered the speech. Targeted killing has been one of the most controversial components of President Obama's war on terror. Actually, he doesn't call it a war on terror anymore. Let's just retire that. President Obama's efforts to hopefully defeat those in terror groups who are trying to attack us. Drone strikes in Pakistan, Yemen, and elsewhere have more than tripled under Obama's presidency. I have said publicly over time that I support the use of drones in limited circumstances, and I know that the drone program is tightly supervised. But on the domestic side, I think its purposes, when a U.S. person is involved, must be transparent and must be publicly debated. The current controversy centers on the legal justification for killing American-born Anwar al-Awlaki, a dual citizen in Yemen. It is not disputed that al-Awlaki was a fiery imam whose sermons and writings inspired terror acts in the United States, including the Fort Hood massacre and the attempted car bombing in Times Square. After 18 years in the U.S., al-Awlaki relocated to Yemen in 2004, where he played a prominent role in AQAP, Al-Qaeda, in the Arabian Peninsula. Though Holder declined to address specific cases, he did offer in this speech last week at Northwestern a detailed rationale for targeting U.S. citizens abroad, and that rationale includes a grid including imminent threat to the United States, the danger of the person in question escaping, or our inability to capture the person alive. I think these criteria are sound, and I don't think that a president needs to go to a federal court before making a targeting decision pursuant to his authorities as commander-in-chief, though he should expect that there could be court challenges on the back end. I also think Holder did not need to and should not have revealed all the contents of the classified memo on which he relied, Justice Department legal memo, but he should share it, and perhaps he has with key members of Congress, and we should have a debate about the United States engaging in actions, basically around these criteria of imminent threat, danger of escape, and inability to capture alive. I think those are the right criteria, but I want to know what you think. In conclusion, there are some hopeful developments. Last week, I attended a meeting of the Director of National Intelligence, Clapper's Senior Advisory Group. I serve on that group and also groups advising the Director of the CIA and the Secretaries of Defense and State. The DNI was created by the intelligence reform legislation that I mentioned, that I co-wrote in 2004. 8 years after that law was signed by President Bush, my meetings last week convinced me that it's working. We have been able to create a joint command structure over 16 intelligence agencies, some of them civilian and some of them defense, which is producing better information sharing and far better intelligence cooperation and intelligence analysis. That was the whole point. And I can actually tangibly now see the results. Took a long time, but hey, we need it more than ever. Certainly, we should give credit to other parts of our government, like those courageous Navy SEALs, for the takedown of people like Osama bin Laden, but to remind us the information they used to find the compound, to case the compound, to know what the house looked like, to map out precisely what they were going to do in an enormously difficult operation, came in most part from the seamless integration of people and ints achieved by the implementation of the Intelligence Reform Act. While Congress deserves kudos, too, for implementing almost all of the 9/11 Commission's recommendations, and we did do that, Congress has ignored one recommendation that I consider crucial. Congress, reorganize thyself. Of course, asking Congress to surrender any turf is almost unthinkable in or outside of an election cycle, but it should not be required that Janet Napolitano, our Secretary of Homeland Security, and others testify before scores of congressional committees, and that legislation and oversight be chopped in little bit pieces. That doesn't help us get prepared for the attacks we will face in the future. Make no mistake, our failure to reorganize Congress and address fully any of the things I have sketched out will have consequences. Maybe in our future the answer is to, well, without solving those problems, we will not have the high side of the moral argument which we need to persuade the next generation of would-be terrorists who are thinking about attacking us. They can still argue that Abu Ghraib and Gitmo and so forth are illustrations of what our values really are. They're not illustrations of what our values really are. And if we can fully debate and change our policies, we have a much better argument to persuade folks, similar to those in inner cities who are thinking about joining gangs, that there is an alternative course that is better, and that is to put down their weapons, take off that vest they're about to strap on themselves or have strapped on themselves, and join the world community, which stands for the rule of law and dignity and respect. Thomas Jefferson, to this younger crowd, was 27 years old when he penned the Declaration of Independence. Alexander Hamilton was 30, and James Madison 36 when they played major roles in writing our Constitution. And those amazing documents have been winning hearts and minds for 236 years. So it's up to students and younger folk in this room and around the country to preserve our traditions and our values. And I suggest that notwithstanding the gorgeous weather outside, that work needs to begin right now. Thank you very much.